today's video, I want to talk about fourth offense OUI charges. My name is Michael DelSignore, Massachusetts OUI lawyer, and I handle these cases throughout Massachusetts. Now, if you're charged with a fourth offense, you've been through this before. The difference between your second and your third offense is that on a fourth offense, you could potentially be held as a danger to the community and held for 120 days without bail. So that first court date, one, be prepared to have bail money. I'd say minimum bail on a fourth offense would be $1,000, certainly $2,500 is not unreasonable, and it could even be higher depending on how long ago your other offenses were and whether you showed up for court on all those offenses. But if you're not, a dangerousness hearing means that the government will have to produce witnesses and testimonies about the underlying facts. So the benefit of that is we'll get a little discovery, we'll get to cross-examine the officer prior to trial. However, if you're held for 120 days without bail. Now, there's two prongs to the dangerousness hearing. One, they're going to show probable cause, but two, they're going to show that no conditions of release can assure the safety of the public. So typically what will happen is, if you're not held, and one of the arguments we would make is that you could be placed on a sobriety. Your license obviously would be suspended, but it could only be suspended for 30 days if you took the breath test. If you refused, you're looking at a lifetime suspension on a fourth offense. But there will probably be a condition from the judge if there's a breath test is that you can't drive during the pendency of the case. Other conditions would be random alcohol screening, potentially the sobriety as well. So that's what you're looking at. First court date on a fourth offense. It's not going to be a routine date, not going to be an in and out, enter not guilty plea, but there probably will be a hearing to determine whether you should be released and under what conditions. Now, once that's done, then in terms of fighting the case, the issues are the same. We got to, one, look to see, can we get the breath test knocked out? Challenge field test. What other evidence is there in order to show that you weren't impaired by alcohol? Now, it's a very high standard to convict somebody of a crime. They're going to prove it beyond a reasonable doubt to a near moral certitude. So one thing we do is look to see how we fight the underlying case. Secondly, we'll look, can they prove all those underlying prior convictions? Did you have a lawyer for them? What happened on your first, second, third charge? In some cases on a fourth offense, maybe the DA would agree to a reduction. It's possible they would reduce it all the way to a second where you'd avoid any jail time, but it might only reduce it to a third offense. So we're going to have decisions to make in terms of, do we want to fight this, risk the minimum year jail sentence at trial, or work out some sort of plea agreement to a lesser charge. The license loss will still be the same. You're still looking at 10-year license loss, regardless of whether the charge is reduced. So if you have a charged fourth offense, feel free to call me. Click on the icon below. It'll take you right to a link where you can get in touch with me. But this is what I do every day. I help people avoid DUI convictions. I'm in court in front of juries, judges, trying to get breath tests knocked out. I'd be happy to help you in your situation.